Hey everybody, happy Thursday. Again, just because it happened to come across my desk, I thought this would be a good example of the kind of thing I'm talking about. And, so I have here looks like a motion filed by Katie probably, um, September 15th, okay. And it's a notice of hearing, and we're having a hearing coming up, I guess, in one of these cases down there in family court, and it's kind of a, so at this hearing, there's 14, okay, there's 14 motions that are set to be heard, I guess, that are set to be heard, that we filed, dating back to, almost a year ago. Filed 10/23/2020, 10/28/2020. These are, and I don't know. We definitely filed more motions than the other side, but that's what you do. And you don't determine really how many motions you file. A lot of times, the actions of the other side do. So, it's just part of being a court that you have to deal with motions that come before it, and and the other side has won. Okay. And there's been a lot of stuff that, everyone is not treated equally. Okay. And there's little tricks and maneuvers, and some people might think, well, but how can somebody who's not the judge, make all these things happen? And if you're a lawyer, you know this, but if you're not, you probably don't. There's all kinds of ways. There's all kinds of little tricks. But, the ones that come into play here is that, come on, man. Come on, man. If there is a, just real life example, it's a motion that was filed, this is in, January of this year, so it's pending 9 months. But it has to do with the selection of, school for my oldest daughter. If it were up to me, we would not be in court at all, and certainly not, resolving issues like that way. But it's not up to me. There's another person involved in this stuff. So unfortunately, these issues have to go before the court. And the issue, generally speaking, is where my daughter goes to school. Well, it was filed in January of 2021, and pertaining to where she went to high school. Okay, she started high school 4 months ago, man. How's that hearing going to go, right? And so if you ask, well, how in the world does it turn out that, a motion which clearly, it's filed in January, you got 5 months for it to come up. How does that end up being heard, in September, way after the fact? The answer is that, the court relies on certain people to schedule the motions, and the judge doesn't have time to do all that. That's handled by somebody. And if that somebody is not treating everybody equally, and grants preferential treatment to certain lawyers, and here's their motions first. Again, 14-1, and we've done a lot of stuff in this case since these motions were, since January of this year. It's just not one thing. It's 15 things, but any one thing, honestly, is pretty problematic. You can't hear people's motions on a priority basis. And one little trick here, if you really want to, if you're not the judge, but you want to de facto exercise the powers of the judge, and you want to grant, for whatever reason, you're going to give preferential treatment to certain lawyers. In their cases, if somebody files a motion and you want to help them out by effectively denying it, okay? If I filed a motion for my daughter, in relation to my daughter, regarding where she goes to school, and if you want that motion to be denied, okay, even though you're not the judge, you're just the scheduler, you're the head honcho there, the Alice Keys, you can be the judge, and you can more or less deny that motion by scheduling it for 4 months after the child is enrolled in school. So, that's just another example, on and on and on. But this is the kind of stuff that I'm talking about. And at the end of the day, man, look, I don't enjoy doing this. I would prefer not to, but these are very basic things that I'm standing up and saying, and I'm not saying them for me, I'm saying them for everybody. And they are these everybody needs to be treated the same. I'm not asking for special treatment. I am just stating the obvious here, which I've never seen in my entire life in any court that I've ever been in. It's, this is not an issue with like a court, deciding something that I didn't agree with. I mean, that happens all the time. And I think we can all understand this idea of, all we are entitled to is an equal opportunity to be heard. That's the constitutional guarantee. That is, again, the guarantee of the law. That is, the guarantee. And we're all adults here, and we can understand that if we have the opportunity to be heard, to say our piece, to show our evidence, we can't ask for anything more. No one is entitled to an outcome, but everyone is entitled to be heard in accordance with the law, equally. And that's the gripe here. It is not a complaint about an outcome or substantive injustice. It's a complaint about procedural injustice. And we got to do this stuff right, man. And at what point does a court stop becoming a court when only one side effectively gets heard? Will the court, I guess, Ms. Keys, be able to say that this motion got heard? I guess. Did it really? No. Was it denied by virtue of its scheduling? It was. And the judge is not aware of any of this. I'm very sympathetic, and I think he's almost certainly a pretty decent man and would not approve of what's going on. But the fact that it's not going on, he doesn't know of it, doesn't change the fact that, look, we have a problem, and the idea is to solve a problem. Now, there's another issue that, I have in front of my desk here on my desk that is worth noting, and, that is this idea that, it's not here, that there are rules. Again, this is about the rule of law. And what that means is that things happen in accordance with the rule of law, not the personal predilections or preferences of any particular actor. Again, this is why the judge wears a black robe, right? So, there's kind of instructions here, right? None of us, myself included, are all that relevant. All we really do is to investigate and present the admissible facts. The law is the law. It needs to be interpreted and applied, but that's the washing machine part, right? So it is the opportunity to be heard in the procedural component of this that is so important. But one of the rules is that, you cannot just walk into court and to just say anything, okay? We have, I assure you, wherever my law is today, a duty of what they call candor towards the tribunal, okay? And what that means is that as an officer of the court, we have to be, honest and truthful towards the court. But it's the spirit of this. It's not a technical truth telling. It is this concept of honesty, which is reflected in the rules, which say, we can be very dishonest while being truthful. In fact, I always say, what is the best way of telling a lie? And it is to tell only part of the truth. This is somewhat common sense, but there is a duty to disclose, is the point, in a lot of circumstances, which doesn't quite seem to be appreciated in this form. So what that means is, you also have to have, as the rule provides, this is the rule of professional conduct, not a rule not a judicial canon, that we have to have a factual basis to say something. So what that means is that if, hypothetically, you walk into if you went out and, I don't know, and just out of the blue happened to represent the ex-husband of, I don't know, hypothetically, Katie Lawrence, and thereby, as Stephanie Dietz is doing, frankly. Okay, and you walk into court because you want to bring me down for exposing all of this preferential treatment that she's getting. you want to bring me down. You can't just walk into court and with no basis whatsoever just accuse me of child abuse or whatever kind of horrible thing else you can come up with. That is flagrantly against the rules. You must point to some factual basis for saying that. It doesn't necessarily need to be conclusive proof, but there must be some evidence of this. And yet that is precisely the kind of thing that is being done. But in any event, I think that that's important, and we need to understand that. All right, thanks.